Welcome to the Dacus Report, hosted by Pacific Justice Institute founder and president Brad Dacus. For 25 years, PJI has counseled, represented, and defended people whose religious freedoms, parental rights, or sanctity of life have been obstructed or violated, all free of charge. We leave no one behind and level the playing field for Americans as they are subjected to the tyranny of the powerful. Now, here's Brad Dacus.
Welcome to Brad Dacus Live. I'm Brad Dacus, president and founder of the Pacific Justice Institute. On today's show, we're going to interview one of our attorneys out of the state of Washington. That's not Washington, D.C., but the state of Washington, which, folks, frankly, is a very hot state for Pacific Justice Institute. Per capita, we probably have more cases there per capita than even California. And California is keeping us busy, as is other states like New York, Florida, Michigan, Texas. But we've got a great conversation. So I'd like to welcome to the program Tracy Tribbett. We got a lot to talk about today, Tracy. And I want to first just thank you right off the bat for the great work you're doing there in Washington State. I know you got a lot going on. We're going to talk about some of those cases that I know people are going to be very, very interested to know about.
Thank you for having me, Brad. It's always an honor.
Yeah, it's great to have you. Now, before we get into some of the cases that we're going to be covering today, we got some elections coming up. I know in California, we have our primary next Tuesday. It's just right around the corner. I think it's June 2nd, if I'm not mistaken, but it's, next Tuesday. Washington State, have you guys already had your primary?
No, not yet, Brad. It's upcoming. I don't know the exact date, but we're anxiously awaiting.
Okay, very good. So I know we've got, oftentimes in blue states, people get discouraged and they say, well, the Supreme Court seemingly has given a signal, in my opinion, that they're going to possibly expand parental rights protection to possibly include parents who have religious objections. And that was because of a recent Supreme Court decision, tentatively, on a case coming out of New York. What are your thoughts?
Absolutely, Brad. There should be more a strengthening of parental rights across the board when it comes to medical decisions. If parents don't want to vaccinate their child, that is their inherent right in accord with their religious beliefs. And Washington State used to have, you could exempt on purely philosophical beliefs as well as religious beliefs, and they've continued to ratchet those down such that now you have to have a doctor's approval. The doctor has to have gone over everything with you in regards to risks of not vaccinating. And the issue with that, Brad, is that doctors can have their medical licenses pulled, as we saw so clearly during the COVID-19 pandemic. Many doctors in our area had their licenses pulled for standing up against the medical norms. And then also in Washington, they allow for a religious exemption but only if the religion does not allow for any medical treatments. So it sort of creates classes amongst religious beliefs where if you are, say, Amish, you get the exemption. But if you're not Amish, you don't get the exemption, which I think is just ripe for a challenge because it violates the law of neutrality.
Yeah, I agree. And I think that there's a good chance that how this is going to turn out. I mean, usually when the Supreme Court, the Second Circuit Court of Appeals, which deals with New York, affirmed the lower court decision saying, like you said, it's no violation of parental rights. So there's no statutory right for parents to religiously, opting out. And then when the U.S. Supreme Court nullifies the Second Circuit and sends it back down to the federal district court and says, hey, we got this Mahmoud versus Taylor case that we decided this last summer where we ruled in favor of parents' rights for religious convictions to opt their children out of any kind of curriculum in any way that violates their faith, pretty much is what they've said, LGBTQ or otherwise, propaganda. Then they ruled that way. They're saying, yeah, we want you, federal district court, to redo your decision, rehear this in view of our pro-parents' rights decision. Yeah. So.
Shot, Brad. It's definitely a warning shot. If you don't take care of this, we will. And then it'll apply to all the circuits, which for us at PJI, that would be great because it'll take care of the Ninth Circuit, of every single circuit, but in particular, the Ninth Circuit, as you talked about with California, here in Washington, same with Oregon, they're planning on having their own recommendations for vaccinations and parting with the CDC, because the CDC is no longer in line with the liberal view that we should pump our children full of every, heavy metal and other harmful substance, even if the parents disagree. So absolutely, the Supreme Court did fire a warning shot, sent it back down, and it tells the other circuits what they're going to do in the same set of facts.
Yeah. So let's say that there's a parent out there who says, hey, my children, I've been told that my kid cannot advance to junior high or high school or go into elementary school unless they've gotten all these different vaccines. And some of them I have convictions against. Maybe all of them I have convictions against. A parent in that situation should probably call Pacific Justice Institute, because I personally think the Supreme Court has made it pretty darn clear where they're siding on this, which is a flashing green light saying move ahead across the country on these kinds of cases, because the referees, the Supreme Court has pretty much already decided how they're going to rule on this. What's your thought?
To get the ball across into the end zone. If there are any parents in Washington state, up and down the West Coast, whose children are being prohibited from entering school on the basis of vaccination, even if you are a homeschool parent who is attempting to have your child enter into sporting events or some kind of other extracurricular activity on a team at a public school, and you're being denied access based on that vaccination status, please do call us. Stand up. You were, you know, just as I said before, for such a time as this, we have to challenge these things as they come up.
Yeah, and I will say also, just anyone across the country pretty much in this situation, Florida, maybe there's a school district in Texas, Illinois, wherever, New England, uh, contact us, folks. If you're in that situation, contact us immediately. Now, sometimes it takes a while for us to get justice. So the parent may have to, do something in the interim, homeschool or find a way to private school or something. But there's a good chance that we can possibly get the school district to exempt, to change their direction when they realize where this is probably going to end up, which is going to be a lot of attorney fees when they in the end up losing from the Supreme Court. A smart school district is one that looks ahead at the probabilities and acts accordingly, even if it means, in my opinion, going against a state statute. That's enough for another discussion for another day. So we won't go down that rabbit hole any more than we already have. But I think it's exciting. Another area that I think parents need to contact us is dealing with boys and girls sports, and I want to talk about that right now. So right now, I know we were able to get 6 states out of our Portland office, 6 states in the country to adopt laws saying boys can't compete in girls sports. And that was challenged. I know in Idaho, West Virginia, it went to the U.S. Supreme Court. What are your thoughts about that? Do you think the Supreme Court's going to rule in favor of states' rights and in this regard? And do you think they may even go farther than that and say, no, under Title IX, all states have to respect Title IX, which arguably requires them to not let boys compete in girls' sports? What say you?
What I got the intimation or impression of, Brad, and listening to the oral arguments, the Supreme Court kind of tipped its hat in the Idaho case towards state rights and how they define boys and girls at the legislative level and that they're entitled to do so. It seemed to me like the West Virginia case leaned a little more into the Title IX, also in favor of separation of girls and boys in sports. And so I think, the Supreme Court has the opportunity here to handle both cases in different ways that sets the bar very high in favor of girls' sports and separation of boys and girls. And, Brad, I'd like to just add, this is unrelated to the Supreme Court ruling, but why can't we just have a separate class of sporting events for transgender individuals? Whether it's track or otherwise, just, it makes no sense to me why we have to put girls in this very compromising situation, swimming, whatever it is. Create a separate group and let them swim against themselves.
Yeah, that's another alternative. Or just have them compete in their biological category. I mean, they still have the muscle skeletal structure of a male. Most of them still have the hormones of a male. They are every way a male. They still have the body parts of a male. Uh, so, I mean, but you're right though. If they want to really go out of their way, they can create a separate third category. That's another viable option. And we'll see how many people they're competing against. That's another problem. If you only have one person like that in a school district, it's sort of hard to compete.
Way. And
Yeah.
that way you're not taking it away from a girl. It
Yeah,
just
you can
helps
compete against yourself, and but anyway, but the point is that they all have an opportunity, and that's what we need. We need to maintain that equal opportunity. The biological difference between a male and a female is night and day, and it's not just urinary tract and reproduction. It's muscle, skeletal structure, and just there's
It's attitude, it's emotions. I mean, it's everything, Brad. And the truth, I mean, my goodness, we have to get back to the truth. What is so problematic about the truth, about consequences? I mean, this is our common thread discussion here, right? Truth
Yeah.
and consequences.
Yeah, and then also hormone levels. Male have 10 times the testosterone level of females. Testosterone is a big advantage in athletic competition. But then even if they arguably say, "Oh no, I take female hormones," well, it still doesn't change your muscle skeletal advantage, which you've been developing for the last 18 years or 16 years of your life since birth. So anyway, I think we've got some great principles there. And we at Pacific Justice Institute, will continue to defend people in that situation. And once again, Tracy, if there's parents out there who find their daughter competing with a male, either in the past or in the future, they see this as a threat. I think they should contact us, because we have 37 offices coast to coast, attorneys all over the country, very unique as an organization. No one has our footprint across the country like we do, by God's grace.
Another, outside of the public school, there are a lot of kids who compete in private sporting events. I can think of my daughter. She competes in USATF, which is private track and field. And in private groups and clubs, it's not a matter of public accommodation. They do not have to accept nor play against
Right.
boys. Girls don't have to compete against boys. And so if
Right.
there are any private clubs out there who are experiencing this, please also reach out to us. It's not just in the public school district.
Excellent.
It's in the private competitive sporting events. Please reach out to us, because you do not, by law, have to accommodate that.
Because of public accommodation doctrine. Excellent point. Excellent point. So very good. Now, folks, when we return, we're going to talk about some other really hot cases that you're going to want to know about right after this.
At PJI, we exist to serve everyone in need of counsel, representation, and defense of their religious liberties, parental rights, and the sanctity of life. We don't take cases based on how high profile they are. We are workhorses, not show horses. Keep current on PJI's work on all the legal challenges we face on a daily basis by signing up for our Legal Insider email newsletter at pji.org. Now, back to the Dacus Report.
Welcome back to Brad Dacus Live. I'm here with Tracy Tribbett. She's one of our attorneys on staff at PJI. She heads up our office there in Central Washington State. And we've got a lot going on, folks, at PJI. And if you'd like to keep up with what we're handling at PJI, just go to our website, pji.org. 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 There you can sign up to get our Legal Insider newsletter. It's something very special. It's exclusive to people who sign up for it on our website. We have over 130 cases in active litigation, folks. There's no way we can cover all those cases. So if you want that information, especially if you're a prayer warrior, please go there and download that. We greatly appreciate it. And you also have some other great free resources there, like 12 Steps to Protect Your Children from Social Workers. We're talking about that thread a little later, as well as other resources like opt-out forms if you have children in public schools anywhere in the United States as well. pji.org, pji.org. Also, folks, we have our big celebration of justice coming up. It's October the 17th. We're already seeing tickets being sold on our website, pgi.org. And we're going to have Emily Campagno. She's an attorney on the 5 on Fox News. She's also on Greg Gutfeld's show a lot. She's also on Outnumbered a lot. She's an up-and-coming star, and she's going to be our keynote speaker. We also have Ray Comfort, who's going to be also participating at our event. And, of course, myself and Todd Starnes is going to be the MC. It's going to be a fantastic event. It's in Orange County, California. If you want more information, just go to our website, pji.org. So I'd like to welcome back to the program now Tracy Tribbett, our attorney, heads up our office there in Washington State. There's a big case that people are watching. It's right now pending before the United States Supreme Court. We've got to talk about it, Tracy, and I know you've been involved in this. This is the Olympus Spa case. So tell the audience what happened in this big case that right now, as we speak, is pending before the United States Supreme Court.
Yes, Brad, it's a very interesting case, if you will. We have clients who are Christians and they're Korean, and they run a traditional Korean spa called Olympus Spa, where they provide a variety of services that are performed in the nude. And the unique nature of these services, Brad, is that you don't have a robe or a towel or a variety of other, bodily coverings while you are partaking in these pools that are hot and cold, rooms, massage, salt scrubs, etc. You're fully nude. And they have always and will always separate men and women. They do not provide services to men. In Korea, they do, and that's traditional there. But in Washington State, they only cater to women. Well, an individual claimed who was a pre-operative transgender. They claimed to have been denied entry into the spa. And through a series of investigative attempts on our part and with our client, it was determined that this person never actually entered the spa. Nonetheless, they reported our clients to the Human Rights Commission in Washington State, and the Human Rights Commission began a very intensive investigation, or a witch hunt, if you will, to force our clients to control speech on their website about who they would let in and their policies regarding admittance to men. And in an effort to try to change the nature of this very private and intimate service, essentially the Human Rights Commission said, no, we don't care about the protective measures, the safety issues at risk here. You are a place of public accommodation. You have to let men in, essentially. But specifically, they favored transgenders. And so when you look at it, not only are they favoring a particular class in the transgender issue against women and against men, because they're carving them out for special treatment, allowing them into places that they are traditionally not allowed. So this case, we sued this office, the Human Rights Commission, as well as some other individuals. And we, in what is called a 12B6 motion, that's a dismissal, we lost at the district court level. The Ninth Circuit reviewed it, and we had, eventually, we had a panel of judges who reviewed the case. And it was, as you recall, a very split panel of judges who were, some were in favor of upholding the ruling, others not. And it's on that basis that we have appealed to the Supreme Court to overturn this misapplication of what we call the Smith law of a neutral law of general applicability.
Yeah. Now, I want to go back a little bit on the facts of this because I want people to understand what we're talking about here. We're talking about a man. He's 100% man. Yes. And he wants to go into a place where women, it's only for women, based on the Korean culture, Korean spa, they're all naked. None of them have any clothes on. And this includes maybe down to 13-year-old girls. They're naked. They're getting in the sauna, the spa, they're getting massage. All this is naked. He wants to go in, expose himself completely naked in front of these mothers with their 13-year-old daughters. And we know for a fact, these radical left organizations don't like facts. but I think it's important because it hurts their propaganda and their routine. But the fact is, the overall majority of men who have gender confusion or engage in gender distortion of their bodies, these men are sexually turned on still by women.
Still attracted to the opposite sex.
So they have this. It's the same impact of victimization on this 13-year-old girl or their mother or whatever. Is the same impact and victimization as if a man who just in a public park exposes himself. In fact, it's worse because not only is the man exposing himself, but the women are being visually violated at the same time.
Pornography, Brad. I mean, if you think about the average 13-year-old, they're not seeing grown naked men. It is pornography. And to instill that image into a child against a mother's wishes, even against a woman's, most women don't want to see a nude man in their intimate spaces. There's nude beaches for that. We do not traditionally allow men and women to be naked together. That is pornography.
Yeah, and even the nude beaches, I'm totally against those as well, just for the record. I mean,
I agree. Are places for that sort of thing.
yeah, if someone in their backyard with no windows available want to sunbathe, so be it. But public decency is not
It's finest.
yeah, this is, and so they're trying to. This is an attempt to degrade our society. The radical left, the Human Rights Commission, the LGBTQ movement. This is a part of their agenda, folks, is to completely degrade and demoralize society. And there's a price paid by that 13-year-old girl and those women, because not only are they seeing pornography they don't want to see, but they're finding themselves visually violated. And that is extremely traumatic on a girl in terms of their healthy development and their future potential relationship with the opposite sex, to be visually violated and stared at and have that in their mind and their psyche. So this is horrific. And the fact that there was anyone on the Ninth Circuit, en banc, that could not see this for what it is, shame on them. Yet there, praise God, there were a number of very level-headed justices. They were in the minority, but still, they called this out for what it was, very directly, very boldly, if you will. And now it's, I'm not going to go into the details, but they use some very specific language, colorful language to say, oh, excuse me, this is what, but they just called it out for what it was. So this is what you are talking about. Boom, truth. And the other side, well, you're using those terms, and and the dissent came back and said, what are you talking about? I'm just talking about reality. You can't, your little tender ears of elitism can't deal with the reality.
Yeah, stop clutching your pearls and deal with the truth of what we're talking about here.
Yeah, so you can't, you're just too offended by the terminology of the reality, yet you have no problem coming down with a decision that's going to victimize girls and their mothers. And so I think they did a great job. I think there's a good chance that the Supreme Court is going to take this up. What do you think?
Oh, absolutely. Because what our listeners need to understand, this case, at the heart of this case, Brad, is the law that came out of the Smith case. And for our listeners who may not be familiar, the Smith case was out of Oregon, and it essentially produced a rule of law that allows for a law that is neutral towards religion and generally applicable towards everyone to be upheld. And it's so broad, particularly with these odd and nuanced types of challenges like we have here with a pre-operative transgender individual. They're saying that you're a place of public accommodation, just like cheese or bread or a motel, a hotel. You have to allow everyone in. However, it's not a place of public accommodation. It doesn't apply to everyone. It's just for women. And so if the Supreme Court were to take this up, and we believe they will, this could very well undo the Smith law, which is so difficult for Christians and for businesses with sincerely held religious belief.
Okay. Thank you so once again, Tracy, for being on the program. Keep up the great work. God bless.
Thank you, Brad. God bless you. Have a good day.
You too. So, folks, there you have it. It's our God-given freedoms we're talking about. Now, let's choose to keep them. I'm Brad Dacus, president of the Pacific Justice Institute. Let's continue the fight for your freedoms.
We would love the opportunity to continue to serve you. Just visit pji.org and click the Legal Insider button to sign up for our email newsletter. At PJI, we help individual employees, employers, business owners, pastors, students, citizens of every stripe through our practical resources, counsel, representation, and defense, all free of charge at pji.org. PJI is an island of stability and assurance in our ever-churning sea of legal and societal chaos. We are here for you.
So, folks, just remember, it's our God-given freedoms we're talking about. Now, let's choose to keep them. I'm Brad Dacus, president of the Pacific Justice Institute. Let's continue the fight for your freedoms.